What if being born on American soil wasn't actually enough to make you an American citizen? It's a heck of a question, right? It cuts right to the heart of our national identity, and it's at the center of a legal debate that's been simmering for a long time. So let's explore what could happen if this idea was seriously challenged. And this isn't just some abstract legal puzzle. To really understand the stakes, let's imagine a future that's not so far away. Say 2026. The Supreme Court agrees to hear a case that could fundamentally change the answer to that very question. Now, this is a hypothetical scenario, but it is built on very real legal arguments that have been debated for years. Okay, let's dive into this. We're going to break down the legal arguments that would put birthright citizenship on trial and explore how a case like this could literally redefine what it means to be American. So, what would a case like this even be about? Well, it would be a direct, head-on challenge to one of the most long-standing principles in all of U.S. law. So in our scenario, let's say the Supreme Court agrees to review a hypothetical executive order. We'll just call it 14160. Its goal would be pretty clear: to stop granting automatic citizenship to children born in the U.S. if their parents aren't citizens or permanent residents. Imagine the arguments are set for spring 2026, with a huge decision expected that summer. This whole framework lets us really dig into the real legal arguments at play. And you know, this entire legal battle, this massive question about who we are, it all comes down to just one crucial phrase, only 14 words from the U.S. Constitution. And this is it, the Citizenship Clause of the 14th Amendment. The entire debate, decades of legal precedent, and the fate of countless people, it all hinges on how you interpret that one highlighted phrase and subject to the jurisdiction thereof. So what does that actually mean? Well, here are the two competing arguments. The traditional view is all about geography. If you're born here, you're subject to our laws, so you're a citizen. Simple, right? But the other argument, the one our hypothetical executive order would be based on, says it's about allegiance. It argues jurisdiction implies complete political allegiance, and under that view, the children of non-citizens don't have it. And the results of that interpretation? It would mean that the executive branch could potentially decide who qualifies for citizenship at birth. To really understand just how massive of a change that would be, we need to take a quick look at the history of how the U.S. has defined citizenship all this time. For more than a century, American citizenship has been based on this principle called jus soli. It's Latin and it means right of the soil. It's a really straightforward concept. If you are born on the soil of a country, you are a citizen of that country. This has been the absolute bedrock of American birthright citizenship. Let's see how this played out. This principle was written into the 14th Amendment after the Civil War, and for decades, courts consistently upheld this broad interpretation. Then, in 1967, the Supreme Court, in a case called Afroyim versus Rusk, actually strengthened citizenship, ruling that it can't be taken away from you against your will. So the crucial point here is that a challenge like the one we're imagining for 2026, it wouldn't just be a minor tweak. It would be a direct challenge to over 150 years of established legal history.
And look, this is not just some abstract legal debate. A ruling that changes the definition of citizenship would have immediate and massive real-world consequences for a lot of people.
The human impact would just be staggering. A narrow interpretation of the 14th Amendment could leave tens of thousands of children born in the United States every single year without automatic citizenship. You'd be creating a new class of stateless individuals right here within our own borders. You can start to see the potential domino effect here. A single ruling could send ripples through our entire system. It would totally rewrite immigration law, affecting everything from voting rights to social benefits. It would set a brand new precedent for how fundamental constitutional rights get interpreted. And it would raise these profound questions about the separation of powers. Can a president really redefine citizenship with just an executive order without Congress weighing in? So back in our 2026 scenario, the Supreme Court's decision could send the country down one of three very, very different paths. So what are the potential outcomes? Well, first, the court could side with the executive order, narrowing citizenship and giving the executive branch the power to exclude people. Second, it could affirm tradition, upholding that right of the soil principle that's been in place for over 150 years. Or third, it could issue a procedural ruling, basically kicking the can down the road and avoiding the huge constitutional question, for now. Each path has vastly different implications for the nation's future. So the ultimate question we're left with is this. If a case like this were to reach the Supreme Court, it wouldn't just be about interpreting 14 words. It would be a verdict on the very nature of American identity itself. How would a decision like that redefine what it means to be an American for all the generations that follow?